Welcome to the first technical session under Module 1 of the Faculty Development Program on Emerging Trends in Administration of Criminal Justice and Forensic Science. The scheme of the entire Faculty Development Program has been divided in the three areas, where in the first module, we are referring and we are specifying the subject of the substantive criminal laws and understanding the basic principles required in the criminal investigation process, the definitions and understanding the development of the criminal law in the present circumstances. The second module is referring to the practices of the enforcement agencies, their major and the minor practices, the pedagogy which they follow while the investigative process, the filing of the cases, and in the further of the determination of the sentences. And the third module is one of the very important parts of this faculty development program, since we are referring to the criminological aspect, as well as we are also emphasizing the study of the victimology, because we need to understand not only the aspect of once the crime has been committed, but we also need to understand the issue of the victims which are left over, or which are basically the leftovers and the crime has been committed. So therefore, formally we do start the technical session on the module 1, that is with reference that is the role and development of the substantive criminal law, with a special reference to specific offenses and the special laws in the present circumstances. Without any undue delay, we are in the presence of one of the very prominent legal luminaries, Professor Iqbal Hussain, Dean Faculty of Law, Jamia Millia Islamia University. Sir, we are honored and obliged to have you in presence, and hopefully the participants of the faculty development program would be enlightened by your knowledge. So kindly take the stage.
Thank you, Madam Dr. Seema Siddiqui. Indeed, as I introduced the subject in the inaugural session, my part of discussion is the role and development of the substantive criminal law with reference to specific offences and the special laws in the era of globalization. Indeed, to introduce the subject and the topic, it is necessary first, very quickly, let us see how the criminal law and administration of criminal law is dealt with. The criminal law, as you know, basically there are two main kinds of law, civil law and the criminal. The criminal law that deals with the crime and punishment. And this is the old age concept of law which is existing in the society. Because the very basic definition of law, that it is a tool to control the society. Society basically protect the life and property of the people. Whereas the later, when the concept of laissez-faire, that is welfare society, was developed, the rest of the laws were developed and that came into being. But basically the criminal law is one of the most important aspects to maintain the peace and harmony in the society. And this criminal law in India was basically maintained by first the Mughal period and then the British. The British period and the British colonial age that developed this aspect from the English legal system, that I do not want to go into that detail. But even the present system which we have, that is the developed by the colonial system. Indeed, Plato said, good people do not need laws to tell them to act responsibility, and bad people will find a way around the laws. In this background, in India, the criminal justice system is an association of the various independent agencies such as police, courts, and jails, which are interrelated to each other and deals with prevention, investigation, prosecution, and punishing the crime, and the criminal activities in the human society. The main objective of such judicial administration is maintain peace, protect the goods, and punish wrongdoers. In India, people enjoy a bundle of rights to live with dignity. Whenever crimes are committed, one of the most fundamental right of the people get violated. Therefore, in order to uphold the authority of Indian Constitution and other laws, the primary duty of the criminal justice system is to keep the criminal activities in the society under control by taking action and administering punishment to the guilty. The criminal justice system functions through four agencies, namely investigation agencies, prosecution, courts, and prison authority. Friends, this has been the practice and the module through which the criminal justice system has been controlled and dealt with. Particularly for doing that, there are three main laws that the colonial system has developed since the court's inception in the British period. The first one is the criminal law. The Indian Penal Code 1860 and the Code of Criminal Procedure 1973 be said to be a general law which deal with the entire range of the legal implications of the crime. The terms of the various criminal offences are defined, their punishment is laid out in the IPC, and also lays down the conditions for liability such as general defenses, exceptions, etc. Procedurally, the CRPC exists as a default and exhaustive procedure by which the criminal justice system moves forward. Why CRPC may be considered to be the general and easy understood from a look at its provisions. The CRP provides for what is legally take place at all stages of the criminal process, beginning from the complainant or the first information report to the stage of investigation, inquiry, and trial. It further provides for the appeal, the carrying out the sentences, and so on. The IPC and the CRPC are supplemented by the Indian Evidence Act 1872, which pertains to the relevance of facts, admissibility of the evidence, and means of proof. This act also exists as a general statute which applies to both civil as well as the criminal trial, and a frame in general terms as to kind of offense under trial. A special criminal law refer to those laws which create a distinct class of offenses for certain acts. This could be premised on the justification based on the distinct such as child sexual abuse or the motive of the crime or such as terror. Overall, over a period of time, the Indian legal system has adopted several criminal statutes that may be termed as a special criminal laws. The law typically defines these offences and proceed to stipulate certain ways in which they may be investigated and punished. Friends, so that has been our the system till now, which is being exercised during the criminal justice system. Now, from time to time, when the mode of crime and committing the criminal activities, the tools are different, which just that does not suits with these three laws, and the need is felt. Time to time, the government of India has established the committees to suggest what new modalities can be established. Accordingly, the central government constituted Malimat Committee in 2003 to discuss reforms to be brought about in the Indian criminal justice system. The committee anxiously considered whether the current adversarial system of justice in India was satisfactory or whether it needed to be changed. After examining the inquisitorial system in the other countries, the committee felt that some features of the inquisitorial system may be adopted in order to strengthen the current adversarial system to make it better and more effective. The recommendations suggested were as follows. The court should take up responsibility to search for the truth. Second, the court must assign new roles to the judges and work proactively. The third one is the court must give directions to the police officer investigating the matter and the prosecutors regarding the investigation and procedure of leading evidence so as to bring out the truth involved in the case. The last one is the court must focus more on giving justice to the victim than penalizing the accused. The view of the criminal justice system must be changed to the victim centric and not the accused centric. So that is the new dimension. That is the paradigm shift that has been suggested. Earlier in inquisitorial system, uh, the uh, the motto is, the object is to punish the accused only. But here, in the shifting of the justice system, which has been suggested, that is based upon the victims. If an accused who has committed a crime has been punished, so that is the punishment and a deterrent uh, sense has gone to the society. But what will happen to the victim? So the new paradigm which has been suggested to be reformed in the criminal justice system, that is the victimology, that is the victim centered. Now coming to the new mode of committing the crime. After development of the science and technology, the new ways of the criminal act has been emerged, which is not being possibly tackled and sufficiently administered by the present system of the administration of criminal justice system. The example which I have given, that is the crime which is as an issue nowadays as a transitional crime, cybercrime, and the terrorism demands innovative approach, and enhance international cooperation, strengthening complementarily, promoting transitional justice, combating impunity, and prioritizing witness protection and victim participation is very crucial. Uh, in investigation and by way of getting truth, narco-analysis test for the criminal interrogation is valuable technique would profoundly affect both the innocent and the guilty and thereby hasten and cause of justice. Conducting the narco-analysis test and brain mapping test on the accused is a process of collection of such evidence by investigation agencies. Since the today it is not only domestic nature of the crime, after globalization, there has been a transnational crime which has surfaced very prominently. Therefore, the transnational crime, how to be stopped, that is one of the most emerging area for today's, that is the challenge to the criminal justice system. As we entered in the era of characterized by unprecedented technological advancement, shifting geopolitical dynamics, and complex transitional threat, the future of international criminal justice become a subject of utmost importance. Hence, the emerging trend and the challenges that shapes the trajectory of the international criminal justice, highlighting the transformative potential of technology, involving nature of the evolving nature of the crimes, the complexity of the global cooperation, and the imperative for the equitable and accessible justice system. This talk aims to illuminate the path forward for the international criminal justice and inspire meaningful dialogue on the strategy needed to address the pressing issue facing our global community. However, the International Criminal Court, that is ICC, stands as the first permanent international tribunal mandated to investigate and prosecute individuals accused of genocide, crimes against humanity, war crimes, crime of aggression, established by the Rome Statute. The ICC operates based on principles of complementarity and jurisdiction over both state parties and non-state parties. When crime occurs within the jurisdiction, the ICC's structure includes the Office of the Prosecutor, the trial chamber, and the appeal chamber. Its mandate serves to deter future crimes, provide justice for victims, and contribute to the development of international criminal law. Indeed, the challenges before the International Court of Justice faces a myriad of emerging challenges to today's global landscape. Transnational crimes, including human trafficking, drug trafficking, and organized crime, present complex jurisdictional issues and require enhanced transitional cooperation. The rise of cybercrime pose unique challenges in the investigating and prosecuting crime committed in the digital realm. The threat of terrorism and its involving nature demands innovative approach to address the complex web of actors involved. Additionally, combating illicit financial flows such as money laundering and corruption requires concerted effort to dismantle networks and ensure accountability in both domestic and international complex. Friends, The recent years have witnessed the emergence of new trends in the international criminal justice. Hybrid tribunals, such as a special court for Sierra Leone and the extraordinary chambers in the courts of the Cambodia, combine international and domestic elements, allowing for the more complex specific approaches. Advanced technologies, including digital forensic, data analysis, and artificial intelligence, are increasingly employed to investigate complex crimes and analyze large volumes of evidence. Alternatively, mechanisms such as community-based justice initiative and restorative justice practice are also gaining attention as means to complement traditional punitive approaches and promote reconciliation. These are the areas which is most important to discuss with the development of the substantive criminal law with respect to the specific offenses and with a special reference to the present global era. I hope that my small discussion, because my time is ending, I have to leave for meeting. I hope that if the time is permitted, later on, uh, hopefully, I will join with you and interact more, particularly with this topic. With respect to this topic, I hope this will be a fruitful discussion, and I wish you a successful 1 month faculty development program, which includes all these areas aggressively. Thank you very much.
Thank you, sir. Thank you, sir. Thank you for the short and but obviously knowledgeable discussion over the topic of the role and development of the substantive criminal law. Hopefully, the participants have gathered certain points with regard to the entire topic, and we request the participants that kindly join us in the upcoming technical sessions, where we would be having a detailed lecture because of the lengthy inaugural session. The today's session has to be cut short, so sorry for this particular delay, or rather the condonation, sir. And your time had to be precise because of that particular session itself. But inshallah, we would be loving to have you in the post technical sessions of the FDP
Hopefully.
program. Thank you, sir.
Honest.
Thank you. So the participants of the faculty development program are requested to fill the feedback form, which would be uploaded on your WhatsApp group in the later evening. Thank you. And we would be joining on Monday for the second technical session.